Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in case number CV21-0701, Francisco versus Affiliated Urologists. These proceedings are being video and audio recorded, so we ask counsel to please identify yourselves and your client at the beginning of your argument. Each side will have 20 minutes, and appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we have read the briefs and have discussed this case in conference. Counsel, you may proceed.
Thank you. May it please the court, Jason Kelly for the appellant and plaintiffs, Mr. and Mrs. Francisco. So the reason we're here, the reason this suit has been filed, is my client's just been put in an untenable situation because a group of surgeons has collectively decided not to provide their patients with information about potentially disabling side effects of a controlled substance, and the FDA says it should be provided to him. And as a result, David Francisco lost his fundamental right to exercise autonomy over what goes into his body. He's
Counsel,
now functionally, yes.
Let me interrupt you for just a moment. There's something happening with the sound that I don't know if we can turn down the microphone or let IT know, but
I think all those controls are outside.
okay. Well, if you can let someone know, maybe turning it down might help.
Stand farther away.
That helps.
That's actually good, yeah.
That helps. Yes.
Thanks.
I don't know if you can manage your notes from there. Please, if you can ask someone to turn down the microphone at the podium. Thank you. All right. Please
All right.
proceed.
So, as a result of the urologist deciding that they weren't going to advise their patients about this potentially severe injury that the FDA said the warning should be given, my client had his rights to self-autonomy violated, and he's now in a position, if the defense argument prevails, unable to vindicate those rights. As the pharmacological science progressed over the years, the FDA warnings on Cipro became more and more severe and more dire. As we've cited in the papers, the scientists from around the United States and the urologists around the Western world all acknowledge the dangers of prescribing Cipro to persons over 60 with the history of corticosteroid use. And I'd note that the warning at issue is particularly important given that urologists have a significant patient population over 60. In every negligence case, the jury determines whether the defendant acted reasonably. And the expert testimony is merely there to help inform the decision. The jury, not the urologist, this is Judge Learned Hand and Cardozo and all these people from the turn of the 20th century, the jury, not the industry, decides what's reasonable and prudent.
Well, I accept that as a general proposition of negligence law. We have a statutory overlay and a legal tradition in this state. The legal tradition in this state is that the jury also decides what the standard of care is on an ad hoc basis after the fact, which has always struck me as a little uncertain as a legal principle. But then we have the statutory overlay of 2602 through 2604, which I believe can fairly be said was designed to make these cases more difficult to bring by imposing these evidentiary hurdles at the beginning of the case. So with all due respect to Learned Hand and Justice Cardozo, or Judge Cardozo, sorry, I think that's where you need to focus your energies here.
That's where I was getting my next sentence, Your Honor.
Okay.
So the first question is whether the expert testimony is necessary. The statutes only apply if expert testimony is necessary for the jury to determine that David Francisco would have wanted this information. And so the two big questions are, what's the role of expert testimony in informed consent cases, and what's applied to David's case? So we're not talking about not being warned that he might have diarrhea or a headache. Those would be immaterial, irrelevant things that would never survive Rule 56. What we're talking about is whether a reasonable person in David's shoes with his medical history would want his surgeon to have informed him of the adverse effects of this antibiotic to him.
That may be what we're talking about in the case at its core. But I think on this appeal, we're talking about something narrower, which is whether the FDA's warning that it directs physicians to give is somehow authoritative on standard of care as a matter of state law. If that question is answered yes, I think you win. If that question is answered no, I don't see how you win.
Well, I would submit to Your Honor that the FDA's, and it's in the brief, the importance of black box warnings and all that, I would submit to Your Honor that it's definitely admissible relevant testimony. It definitely should get to the jury on the question of whether it's material, and then it's to the jury to decide whether it's material, whether they can believe David or not, that he would have chosen a different antibiotic. I mean, all these things. So at the first...
Well, I understand that's your view of what should be. But what I'm wondering is there any authority to suggest that the FDA's pronouncements somehow are authoritative in themselves such that they obviate the need for expert testimony? If, for example, the risk here was serious but remote, like Cipro can give you cancer in 50 years, you could imagine that sometimes that warning might slip. And the FDA hasn't told you that you have to warn about every potential carcinogen out there. This is a much more specific directive. Do you have a case or a reg or anything to say that these directions from the FDA are authoritative?
The Arizona Administrative Code, and we cited that in the papers, requires physicians to advise their clients of the dangers and precautions of these drugs, of controlled substances. We also have the federal regulations that set forth the need for the black box warnings, and we cited these in the papers as well. So we do have federal and state regulations saying you need to advise people of precautions when taking these.
So you're arguing then, if I can rephrase it, not that this is a standard medical negligence case where a medical standard of care needs to be established. This is a straight out-and-out tort case which, following in the footsteps of Kiraz and Gibson, has a public policy announced by a different branch of government, and that's all we need to follow.
I don't think that's... I think I would agree that this is not a medical negligence case. This is not a question of whether they need to be informed that in a urological procedure there's a 1% chance of a perforated bowel that could get you sick. This is a negligent disclosure issue. This is an issue of disclosure. This is, did he perform well or perform poorly? It's, was the disclosure made? And the disclosure obligation, yes, Your Honor, we believe is based at least in part on the federal and state regulations, if not the doctor-patient relationship, the ethical duties to come to a shared decision about how healthcare is going to move forward. So, I mean, Your Honor's correct in that we are not alleging improper surgical technique. We are not alleging improper robotic equipment. We're alleging improper disclosure, negligent disclosure. And the confines around that we submit to the court are material and relevant information that would have made a difference. So again, you know, not diarrhea, not a headache, not a sore throat. When you are at a greatly increased for tendon rupture, are you entitled to have that information from the doctor prescribing the information? We say yes, based on federal code, state code, and just the relationship between the doctor and the patient.
So your position is that essentially it's so obvious to a layperson that there needed to be a warning that your client does not need an expert to come in and testify to that fact. Is that a simple,
Yes,
straightforward way?
and there are, in negligent disclosure / informed consent cases, there are situations that an expert might be necessary. For example, if the FDA hadn't given this black box warning, but other urologists in the community would say use drug A over drug B, then you'd have to bring in an expert to explain that. But what we have are, and I think it's on page 15 of the reply brief, if I put up those 2 slides with highlights in front of the jury, I think a jury could determine for itself whether David should have been told that information.
So if it's so straightforward that a layperson can determine that there needed to be this warning, why was it impossible for you to find a doctor who could say the same thing?
Because of the 2012 paper from the American Urology Academy, AUA I believe it is, that's just behind the times on the science. The 2012 paper, they should have revised it and advised differently when the 2016 warnings came out. Just like the scientists have done, just like the other urologists around the Western world have done. And now we can't go, my retired dentist client cannot go lobby the American Urological Academy to change its papers. I mean, that's the point of tort law. That's why Learned Hand and Cardozo and everyone else said the jury gets to set the standard. This is a closing argument I sometimes give, but the jury decides. It's not a group of doctors. That's why we take people, a jury of your peers, take people off the streets, because that's the way we can tell the doctors what we want to know. If we leave it in the hands of people who don't update their publications, we have what happens to David Francisco. And that's not the way our American civil tort system works. And it's not a difficult, I'd submit to the court, there's not a lot of difficulty in here. We're not talking about the 57-page insert. We're talking about half a page out of it.
Okay, so you've said that the AUA does not recommend, and I'm quoting, does not recommend that Dr. Art should have provided David with the FDA warnings, close quote, and that you can't find a board-certified urologist willing to testify against the recommendations of his own board. But what is your position for that AUA position? The opening brief references Exhibit 7 of the appendix, but where does it say what the AUA position is regarding warnings?
The AUA position sets forth the only times you do not prescribe a a Cipro family drug. And this is not one of those times. That paper says...
Does it say anything about disclosure?
That pointed question, I'd have to look at it to determine.
And if it doesn't say anything about disclosure one way or the other, I guess I would come back to Judge Cruz's question. Why not just get an expert? It seems like a fairly non-controversial point.
Well, I've been asked not to disclose the people the urologists we've talked to, but I can't find one to do it because of what the board says.
Even though the board is silent on disclosure?
Because they believe it's within the standard of care to prescribe Cipro based on the paper that says you only don't give out Cipro in certain situations.
Okay, I guess I'm still failing to understand, because you've made pretty clear that this case isn't about whether prescribing Cipro was the right move. You've made pretty clear that this case is about disclosure of the risks of Cipro, right, consistent with the FDA, and it seems that the board is utterly silent on that whole question.
The board doesn't think it's important to disclose. In contrast, we have the Europeans and the Canadians who say you need to discuss this with your clients. So all I'd point to is the fact that since the board says you only don't prescribe Cipro in certain situations, the response I've received from highly accredited urologists is it's within the standard of care to prescribe it without telling them. And I don't know that they talk about whether you need to disclose or not, but I will say that in 2016, the FDA warnings changed, and the AUA has not changed.
So counsel, had your client been warned, your client been provided this FDA warning, what would your client have done? Were there other drug options
There were.
to take? Would he have declined the surgery? Trying to work out the causation piece of this.
Sure, and I think we put it in his affidavit, he would have explored other antibiotics. And the jury's free to accept that or not. But so the causation, the fact question on causation's there. So I don't know that, and we have the proximate causation on his injuries as well from both his treating doctor and a pharmacologist who teaches medical students.
But how can the jury consider that, whether he would have been able to consider other antibiotics if there's not expert testimony on that?
We do have expert testimony that other was available. That was John Budney. But the question is, would it changed his decision-making process? Yes. Maybe he would have decided this was a benign enlarged prostate. He may have also decided simply, I'll get up twice a night rather than risk tendon rupture. I mean, there's a wealth of possibilities, but we have the fact questions in the record, and the jury's allowed to consider those. I don't know that the defense has really hit it that hard on appeal, but I think that's just replete with fact questions. Unless there's questions at this time, I think I'd like to reserve the remainder for rebuttal.
All right, thank you.
Good morning, Your Honors. Eileen Gilbride for the defense. I think we have pretty clear authority in Arizona that says expert testimony is needed in informed consent cases. We have Redeser versus Nelson from Supreme Court, and we have McGrady versus Wright from Court of Appeals Division 2. And both of them say that whether or not the surgeon is under a duty to warn depends on the circumstances of the particular case and upon the general practice followed by the medical profession.
I don't think anyone would disagree with that proposition. The question is, in this particular case, are the circumstances such that expert testimony is not required because the FDA has already substituted in as that expert?
Yeah, and I don't think there's any authority that says FDA package inserts substitute for expert testimony. In fact, there's two cases that hold the opposite, and those are Kraft versus Peebles, 893 P. 2nd 138, and Salgo versus Leland Stanford University, 154 Cal App 2nd 560. And both of those say package inserts do not substitute for expert testimony. And the reason is that the purpose for package inserts has nothing to do with the standard of care applicable to practicing physicians. They have to do with manufacturers' desire to sell their product and to meet whatever regulatory requirements are out there for package inserts. The purpose is not to set the standard of care for physicians.
The FDA doesn't normally help with marketing. I mean, if the FDA includes a warning that is presumably clear enough for the public to understand without expert testimony, but nonetheless tells doctors that they need to inform their patients, just that act of informing strikes me as a less medical issue than the choice of the drug, for example.
It is a medical issue, though, Your Honor, because...
I said less medical, right? I mean, you're talking about medicine,
yeah.
but the idea is tell the patient this, not choose this drug over that drug.
Right. Well, first of all, what the warning says is tell patients that they could have this reaction so that they can discontinue the drug if it occurs. Not tell the patient about this so that they can choose a different drug. The black box warning doesn't say that. And it couldn't say that because the medical professional has to use his or her judgment to know whether we could even tell the patient not to take Cipro, that there's another drug involved.
Well, maybe
Judge,
there's no drug, though. I mean, can't a patient just decide, as many do when they go to the dentist and say, I don't want Novocaine? Can't a patient just decide, I'm not doing antibiotics?
We don't know that. Well, I mean, I suppose, but if, you know...
Well, 40% of the United States decided not to get COVID vaccines. I assume that some percentage would decide not to take antibiotics if they were appropriately scared off by a warning.
I mean, I suppose, but doesn't that involve medical judgment on whether or not the patient's presentation, his history, his his prior medical issues or whatever, they have to know in order to know whether this is a material risk to advise the patient of. That takes medical judgment to know. Is this a material risk or isn't it? I mean, and counsel says, well, not diarrhea, not headaches, not this, not that. But we don't know in this particular case, with this particular patient, with this particular history, how does that all fit in?
Well, we know what the doctor should have known. I don't know if the doctor did know about the steroid therapy, which is specifically mentioned in the warning. We know that this patient fits the warning profile pretty carefully. And, I mean, you can't get your nails done without having someone ask if you're allergic to medications. So presumably, at some point, somebody asked some questions about his susceptibility to risk from medications, but maybe not. The point I have is the FDA has specifically said for this class of patients, you at least need to have a conversation. And we're saying that expert testimony is required. Why? Because the jury can't understand that warning, or because a group of urologists should be able to supersede what the FDA says?
No, potentially. I don't know whether lay people will interpret the warning the same way a medical professional would interpret it.
Well, that's why the FDA says for the medical professional to give the warning.
So that the patient can discontinue if necessary, not that another drug can be given.
Yeah, I don't care about other drugs. I mean, to the extent that this case is about other drugs, trust me, I think you've got that point solidly on your side. This is about whether the patient's own decision whether to take this drug or not was impacted in a way that hurt him.
And our Arizona law, that we have already in place, Arizona Supreme Court, Court of Appeals already says we judge the professional's conduct on the basis of what a reasonable professional in his or her position would do.
So we might have an Arizona case saying, based on the silence of elite members of the profession, we believe that doctors have the right to ignore FDA directives as to how they or what they communicate to their patients. Can you imagine a case like that coming out of this court?
I don't believe there's silence, though, because
they're not here. There's no affidavit. That's why you won the motion.
That's exactly right. Because we have
silence.
Well, we have silence because it's not the standard of care. I mean, and it's because medical professionals who are in practice, who have worked with this drug, who have worked with patients all of these years, who have studied it, believe in their medical judgment that under these circumstances, whatever these are for their patients, these are the material risks that need to be communicated, and these aren't.
Well, I don't want to be unfair in my language, but are you suggesting then that we issue an opinion saying that doctors are empowered to just override FDA directives if they find it desirable to do so?
I'm not sure override is the right language. I would use medical professionals need to apply their medical judgment to these package inserts to determine which of these warnings, 52 pages of it, even if there's, one black box page, which of these are most applicable to this particular patient in these particular circumstances for these particular reasons. I mean, that's why we have the learned intermediary doctrine, because the manufacturers will put everything under the sun into these inserts, knowing that it's the learned intermediary who's going to read the insert and understand from the patient's, from his dealings or her dealings with the patient, what's important for that particular patient.
I actually wasn't focused on that, and you've raised an interesting question. As I've encountered the learned intermediary doctrine, it's always been to insulate the manufacturer from more aggressive therapies by the intermediary, not used in the way that you're describing. I'm not saying it couldn't be.
Yeah, I'm not sure I understand that. I'm not sure I understand what you're saying, but my understanding of the doctrine is that because the learned intermediary is the face-to-face contact with the patient, it's the learned intermediary who has the obligation to gather all of that information and decide within the physician-patient relationship what's critical to inform this patient of. And so I don't think it's necessarily, I forget the word that you used, overtaking the FDA. It's taking that information and applying their medical judgment to it, which is and doing what reasonable practitioners need to do. And if there was a practitioner out there who said, you know what, you're right, this needs to be informed, this needs to be told to the patients no matter what, in all circumstances, then they would have found an expert to do that.
Well, if this case had gone to trial, let's say, and the defense had won, would you be looking for an opinion that says, yeah, in this case, this patient really didn't need to be warned?
No.
Do you have any facts to suggest for a moment that this patient doesn't fit perfectly the profile of who needs to be warned? So perfectly that a lay person could determine that?
I think that's a matter of medical expertise, because I think what you're saying is if this case had gone to trial, there would have needed to be experts on both sides saying what this physician did was within the standard of care among what reasonable physicians do.
I'm not making that assumption that there would have needed to be expert testimony. Almost every case I've ever dealt with, there needs to be expert testimony. But there are the very clear cases like
right.
You amputate
the
wrong
sponge.
leg,
Right.
that kind of thing, where you really don't need an expert. And I'm wondering here if we find ourselves very narrowly for just a portion of this complaint in that situation where the FDA has said, well, anybody in the public should be able to understand this, and we're going to publish it. So why then do we need an expert to have a jury understand what the FDA thinks a patient should be able to understand?
I'm not sure, and I don't know the answer to this, but I'm not sure that the FDA publishes I think that I'm not sure the purpose of the inserts, the package inserts, are going to the prescribing doctor. They're not going to the public. It's not like they put out on a website, hey, public, everybody should be warned about Cipro. These package inserts are going to prescribing doctors, for the prescribing doctors to take the information and apply their medical judgment. I don't think the purpose of these FDA inserts is to, broadcast to the public, this is what you're entitled in a medical malpractice case.
No. But they are entitled to broadcast to the general public information that the FDA has rightly or wrongly concluded that the general public can understand, that it's worded in such a way that it conveys meaningful information to somebody who is just reading this without expert assistance.
I don't know. I mean, I haven't read anything. In all of the cases that I've read, I've not read anything that says a patient should read the Cipro, prescription insert and understand and be entitled to what that says over what his medical professional said. And that if the patient reads the insert, then the professional who doesn't inform him of what the insert says falls below the standard of care as a matter of law? I mean,
I understand the confusion, and it's partly because I think we share this confusion because we're at such an early stage in the case, right? If we had a bit of a record and your client had offered some explanation as to why a warning wasn't appropriate, number one, I'd love to hear it, and number two, I think then we would have a factual dispute that would probably work to your client's favor, because walking into court without an expert, the plaintiff is just hoping that the jury will read this, understand this, and discredit the defense expert who said it wasn't necessary to inform. That's a pretty weak tactical position to be in, but nonetheless, isn't he entitled to be in that weak tactical position for a little while?
I don't think he is, certainly not under current Arizona law. I mean, the Supreme Court has said we need an expert in informed consent cases.
Has it? Or has it said you needed an expert in this informed consent case?
Well, it says whether or not a surgeon is under a duty to warn a patient of the possibility of specific adverse result of a proposed treatment depends on the circumstances of the particular case and upon the general practice followed by the medical profession in the locality. And the custom of the medical profession to warn must be established by expert medical testimony. That seems pretty straightforward, and that's from Redeser.
Well, yeah, but it talks about a course of treatment, not the prescription of a drug that comes with its own set of warnings. I mean, there are all sorts of vicissitudes in treatment that might compel a physician to say different things, but this seems to be one of those rare cases where it's so circumscribed by the black box warning that I wonder how an expert could credibly say, yeah, just forget about the FDA.
Well, we don't know what anybody is saying. All we know is that plaintiff can't find an expert to say that our doctor fell below the standard of care. And all we know is that both the Redeser and the statutes require him to have that preliminary expert affidavit. That's the current Arizona law. I know he wants to change it, but respectfully, this is not the forum to change that law. We already have the law. We have those two cases that I cited that say FDA warnings are not even prima facie standard of care. And so that's what we have. That's the state of the law right now. I'm not sure how we can go against what the law is right now.
Well, I mean, again, that then sort of depends on how you couch the claim, right? Because if this is a medical negligence claim challenging the appropriateness of the course of treatment.
And he says it's not.
Right. I'd probably agree with you, but the question is, can there be this little narrow side category where you're not really challenging the treatment, you're just challenging the disclosure, and the patient himself says, the non-disclosure was the cause of my decision to do what the doctor recommended. That turned out to be a bad decision that I wouldn't have made had I had disclosure. Understood,
but the standard that we're facing here today in a medical negligence case is, did the physician meet the standard of care required of reasonable physicians in his position? And I'm not sure how or why a jury could make that decision, what reasonable physicians in his position would do when it's full of medical judgment about how this patient has presented himself, what his history is, and the entire circumstance of his treatment. This is not like a sponge in the abdomen case. That doesn't involve medical judgment. It's not like, leaving a cloth in somebody's abdomen. Those are the very narrow exceptions to the expert requirement because it doesn't involve medical judgment.
I'm reluctant to ask another question in case one of my colleagues has one. But if not, I will say, let's assume for a moment that 2603 had never been passed, and we were here at the summary judgment stage where you had submitted a declaration saying this non-disclosure was fine in these circumstances. Sure, he fit all the categories, but whatever that, I'm sure you'd get a better affidavit than that.
Yeah.
And in response, the plaintiff produces no declaration. So we're basically where we are, but at the summary judgment stage instead of the motion to dismiss stage. Is it your contention that the plaintiff's own declaration saying, hey, I should have known this, it's in the FDA, and I would have made a different decision, even if that meant taking no drug, that's not enough to generate a genuine dispute of fact?
Correct, because that goes to causation, not to standard of care.
Okay. All right, fair enough.
I don't know if you need me to go over the constitutional issue. I don't think it really needs discussion, but I'm happy to do so if you think it does.
You have 1 minute, and you can use it as you wish.
Well, the statute, the expert affidavit statute certainly doesn't abrogate his right to bring a claim. It doesn't infringe on his fundamental right because it doesn't require him to hire an expert where none is needed. It doesn't take away his right to file a suit. It doesn't restrict the availability of experts so much that there's no expert even that who would ever be qualified to testify for him, and it doesn't implicate a suspect class. So, and it furthers a compelling state interest or a legitimate state interest in limiting frivolous malpractice suits. In fact, the statute in this case has worked exactly as it was intended. It precludes claim that lacked the expert support needed to make out a prima facie case, and that's exactly why the trial court correctly dismissed the case.
Thank you.
Thank you.
Counsel, before you begin responding, Exhibit 7, Record on Appeal 53, seems to be the patient warning that Francisco got with the drug, and we'd just like to clarify whether he's saying he did not receive that Exhibit 7, which says, read this medication guide before you start taking Cipro, and also advises of serious side effects, and advises risk is higher if over 60 and taking corticosteroids. Can you tell us whether what his position is?
I don't know, and I don't know that the record has, and I don't know the answer as to whether he received the 50-page insert or not. His testimony is he didn't receive the warning. That precise question as to whether someone gave him the black box warnings, I don't think is in the record, and I don't know the answer to the question anyway. So,
would it make a difference if he had received the FDA warning?
On a Rule 56 motion, probably, yeah, but not for today.
Okay. All right, go ahead.
Sure. And I will point out in Dr. Art's records, it's part of the record in this case. Corticosteroids were mentioned in the medical record, so he did know about that. I want this idea that doctors get to decide and set the standard, the general practice and custom. If we go back to the Hales case, which I think is the first or second informed consent case in Arizona, they cite to Cobbs versus Grant. And Cobbs versus Grant most clearly does not say doctors get to decide. This is on page 22 and 23 of my opening brief. They talk about how it's what's relevant to the patient's position. Now, medical judgment can come into that. And certainly Dr. Art can get a urologist to come in and say, here's why we don't advise people over 60 on corticosteroids of this adverse reaction. But the question, and we've pointed this out in the treatise, Dobbs on torts says this is a negligent disclosure action, not a medical negligence action. So to the extent that experts' general custom and usage somehow control standard of care is simply not the case law of Arizona. To the extent that there's been subsequent cases to Hales misciting Cobbs and Hales. I think I dealt with that. It's pages like 18 to 25 in the opening brief. All the cases upon which Arizona relies say you look at what the patient would want to know. Now, and you can bring in the Reusser case. It was a lady who had a very minor fistula after a surgery that caused her no problems and went away. That's exactly what I'm saying, too. That's not material. That's not relevant. That's not something that you should survive Rule 56 on. You should survive Rule 56 on something where you now have to spend your life in back braces and neck braces and elbow braces and knee braces all the time. So I would just request, I'd ask the court to spend some time, I think it's pages 19 to 25 of the opening brief, and look at those cases on which Arizona relies. And it's pretty clear, Professor Dobbs, it's a disclosure issue. It's what's important to the patient. Just as to the constitutionality, they're both divisions of this court and the Arizona Supreme Court have said the statute's constitutional, but we can envision a situation in which it may not be. And, I mean, I would just submit this has got to be it. This is the conspiracy of silence. Back in the old days, we had, if you sued a rural doctor in whatever, Graham County, you need to get a doctor within 100 miles, but the only other ER doc in Graham County is his partner. That abrogates the right to bring a claim if it has to be within that geographic limitation. I'm just suggesting in the digital age, the geographic limitation is perhaps not there anymore, but this is the same thing. You have to get one of your partners who does the same thing to testify against you. And I think as applied, if we get past my first two arguments about whether the statutes apply, whether it's a patient-centric or a doctor-centric qualification, this is the case where as applied, the statute abrogates the right.
Thank you, counsel. Counsel, we thank you for your arguments. This matter will be taken under advisement and we will issue a written decision in due course. We're at recess.